the interesting session. The next session is an online webinar hosted by the Indian International Arbitration Centre. The topic of the session is Arbitration and Insolvency Rendezvous. The session will be displayed here on a LED screen, so I request all of you to be kindly seated. The session is moderated by Ganesh Chandru, and the speakers include Hannah Fry, Ajinderpal Singh, Anant, Merathia, and Jan Schaefer. Thank you.
Hello.
Hi.
Hi, Hannah.
Hi, Ganesh.
Hi. Hi.
Hi.
Okay. So, ladies and gentlemen, welcome to this webinar, which is proudly hosted by the India International Arbitration Centre as part of the India ADR Week 2025. It is very efficiently put together by the Mumbai Centre for International Arbitration. My name is Ganesh Chandru. I am a member of the India International Arbitration Centre, which is a centre established by an Act of Parliament and has been declared by statute as an institution of national importance. On behalf of IAAC, I would like to thank MCIA, the Registrar, Secretary General, and all those involved in putting together this India ADR Week for having invited IAAC to host this webinar. In fact, ladies and gentlemen, I was in Singapore a couple of weeks back for the Singapore Convention Week. And I was at the SIAC Symposium. And there was a launch of a very interesting protocol called the SIAC Restructuring and Insolvency Arbitration Protocol. That got me thinking when I was asked to, kind of host this webinar and moderate it, as to why not have this as a topic for discussion, because there are so many nuances, especially in India and, with the Insolvency and Bankruptcy Code, and also in the common law world in England and Singapore and other countries, and also in the civil law world. We are very grateful to all the speakers who have agreed to be on this panel today. Ms. Hannah Fry, Barrister at Law, Essex Chambers in London. Mr. Ajinderpal Singh, Senior Partner, Dentons, Rodyk and Davidson, Singapore. Mr. Anant Merathia, Independent Counsel and author. He has authored a book on insolvency. He also runs a firm called Merathia and Partners and Associates. And Mr. Jan Schaefer, who is a partner at King and Spalding, both counsel and arbitrator based in Frankfurt in Germany. But I'm sure in addition to Germany, he'll probably throw some nuances from other civil law countries, if at all relevant to any of the questions that I put to the panel here. So with that, we straight go into the topic, which is arbitration and insolvency rendezvous. I mean, just thought we'll make it a little colorful and add a bit of, we all strive for simple English today. But I'm sure Ajinder will agree with me that if you don't put any of these terms, the topic is not attractive. So rendezvous, if anybody doesn't, know the meaning, it means a meeting place. So arbitration and insolvency, where do they meet? Do they meet very regularly? Or, what happens when this meeting of these two, one is, of course, when a company goes into the insolvency process, and let's say parties have agreed to have an arbitration clause in their contract, or they agree for an arbitration after the dispute arises. So there are several such nuances surrounding these topics. A lot has been written on these two topics as well. There are excellent articles. But I think it's timely, especially because we are doing the India ADR Week. There's a lot of developments in India, developments in Singapore, and I'm sure there are developments in England as well as in the civil law, continental Europe. So with that, kind of background, when a company goes through insolvency proceedings, right, it may have an effect on prospective dispute resolution, be it litigation or arbitration. It can have an impact on the working and existence of the company itself, right? So this seminar will focus on the interplay between arbitration and insolvency. And to kick off the webinar, one important aspect in an arbitration, of course, if you don't have an arbitration agreement, then you cannot have an arbitration at all. That's the basis. But another important aspect is the subject matter of the dispute should be arbitrable. That is, parties must be able to resolve it by way of an arbitration proceedings. while arbitration is party autonomy driven, I guess if a particular dispute is not arbitrable, then there's no point in resolving the dispute, because as per Article 34 of the model law, which is the equivalent, which is reflected in Indian Arbitration Act as well as in Singapore, if a dispute is not capable of settlement by arbitration and you go ahead with the matter, then you can take that as a ground to set aside the award made in the arbitration. So first question I want to throw open to all the panelists, starting with of course, Hannah, the position in England on whether claims involving a company that is going through insolvency, whether it is arbitrable.
Thank you, Ganesh, and good afternoon. Thank you for having me. And I was particularly captured by the term rendezvous, because there is this inherent tension between insolvency being a collective process on the one hand, and then the parties' private consensual choice of arbitration to resolve their disputes. And I think the answer to this question really turns on 3 points: or when the company has gone insolvent, what type of insolvency, and what is the nature of the claim underlying the dispute. Generally, where an insolvency process remains ongoing at the time arbitrations commenced, we have an automatic moratorium which will prevent the arbitration from proceeding unless leave is granted by the court, similar to India. And I understand we'll come on to that later. But in terms of arbitrability specifically, the courts have generally taken quite a pro-arbitration stance in England and Wales and sought to protect the party's choice to arbitrate where possible. So, for example, in Fulham Football Club Limited v Richards, a Court of Appeal decision, it was held there that the determination of whether there's been an unfair prejudice in a shareholders agreement type claim, it was held that that was arbitrable, because it was thought that really this was about internal disputes and alleged breaches where the parties were intended to coexist as members of a company, and there were no express provisions in the Arbitration Act or the Companies Act which excluded arbitration as a means of resolving this dispute. So it was considered to be a private dispute in relation to the affairs of a solvent company, and importantly, no order for winding up was sought. This has been built upon by our commercial court in recent decisions, and in particular, Nori Holding Limited, a 2018 commercial court decision, which concerned an application for an anti-suit injunction to restrain Russian proceedings in breach of an arbitration clause. And the key question here was whether an injunction can or should be granted to restrain proceedings brought in accordance with the insolvency law of a foreign state to set aside a transaction at undervalue. And again, the judge held that the dispute was arbitrable, and actually the factual dispute was quite straightforward in terms of whether a fraud was carried out against the bank or not. So the court focuses on whether the subject matter of the claim and on what its substance is, rather than the form of how it was brought. So the starting point really is to consider whether a particular insolvency related claim is in its nature and substance capable of being determined by arbitration, and would this affect third party rights such as creditors, and is that going to be affected if it is arbitrated, and that really is the focus in England and Wales, looking at the substance and not the form, and is there anything in the statutes that affect it, that prevent it being arbitrated. But that's not to say that all insolvency related claims will be found to be arbitrable. If you're looking more at director type of claims that do have public policy objectives of protecting the public, so for example wrongful trading, that's unlikely to be arbitrable in our jurisdiction.
Thank you, Hannah, for that. I would say opening innings. We are all cricket crazy chaps, like in England. So it was a good. I think in this short time, you've not only brought out all the principles, but also the leading cases. Moving from England to Singapore, Ajinder, in terms of arbitrability of insolvency matters, I mean, by the company, could you please throw some light from Singapore law angle?
Thanks, Ganesh. And thanks, Hannah, for that very detailed explanation. The key point that Hannah made, and I agree with, is you have to consider the type of claim. She mentioned claims for wrongful trading or director sort of claims are not usually arbitrable. And Singapore here has gone through a massive change recently. Ganesh, you mentioned the protocol, we'll come to that. But if I go back in time, in 2011, our Court of Appeal had to look at this issue, and there's this case of Larsen Oil. Basically, what had happened was Larsen, who was in liquidation, had entered into an agreement with Petroport where they had services rendered and so on, and payments were made. So the liquidator of Larsen found all these payments to be dubious and said they amounted to unfair preference claims. So what does that mean? Claims that basically are meant to enable a creditor to steal a march on the rest by trying to get paid beforehand. So in insolvency, the big issue is you want to bring in all the assets, the liquidator holds them, he adjudicates what are the proper claims, and then he distributes the assets on a pro rata basis. So in this case, Petroport asserted, no, you can't take me to court over this. I have a management agreement which has an arbitration clause. So because of that clause, you have to take me to arbitration rather than to court. And so what our Court of Appeal had to do was to consider, are these sort of issues where a liquidator is claiming for monies back into the estate, are they arbitrable? As a matter of public policy, should we allow it? And what the Court of Appeal did was they made a distinction pre-arbitration and pre-insolvency and post-insolvency claims. So pre-insolvency means we have an agreement. 10 years ago, we had an agreement whereby we will supply goods, and if there's any dispute, we go for an arbitration. 10 years later, you have insolvency, but monies are owed to me under this agreement. Clearly, that's pre-insolvency. Post-insolvency means this sort of claims, unfair preference, wrongful trading, stealing a march. So here, the Court of Appeal had a problem. This type of claim here seemed to encompass both bits, pre and post. But the Court of Appeal said this kind of issue where it's so close to post-insolvency issue, meaning it affects all the creditors in the sense that you should not be holding on to this money if it's wrongfully taken because it's for everybody to enjoy in terms of creditor recovery, then this sort of claims are not arbitrable. You have to go to court. But later on, as I will show, Singapore has now gone the other way to allow almost anything and everything insolvency related to go for arbitration. But having made that dramatic statement, I will introduce the caveats to this in our follow-up questions as they come.
Sure. Thank you. Thank you for that overview on the Singapore aspect, especially the Larsen Oil case, which was very, very well crafted, I would say, by Justice V.K. Raja, as he then was. And I think that's, in my view, one of the best judgments in the common law world. And so whereas you very beautifully explained the pre-insolvency and the post-insolvency kind of scenarios. Now moving on to our home ground in India. Anant, can you discuss about the arbitrability issue vis-a-vis insolvency in the Indian context, please?
Good afternoon to everyone. Thanks, Mr. Ganesh, for this lovely opportunity and the rendezvous that we're catching up with. See, the whole corporate insolvency concept.
I think you need to increase your volume a bit or come near you.
Am I audible? Sorry.
No, you're audible, just the volume is a little. Yeah, that's fine. Go ahead, please. Yeah.
Yeah. So you're fine. Yeah. I hope I'm audible. So the corporate insolvency regime in India is something that's come in 2016. And this whole concept of insolvency per se, especially in the corporate sector, is a newer regime. It's not something which was there earlier in India prior to the law at hand, 2016 Insolvency and Bankruptcy Code. We will talk about what the regimes earlier and so on and so forth. But the issue of arbitrability of issues between creditor and debtor, or for that matter, shareholders, so on and so forth. Whatever were these issues, again, if it is prior to an admission of a company into insolvency, it can still be arbitrated to the extent as long as it's about the distressed company, it's a creditor vis-a-vis a debtor issue, or it's an investor-investee issue, or shareholder disputes, they can be arbitrated. But once a company is admitted into the corporate insolvency process, it becomes a proceeding in rem, and as a result of which there is one centralized tribunal, the National Company Law Tribunal, that runs the entire insolvency process. And as a result of that, of course, proceedings are affected, so on and so forth. So as far as insolvency or winding up issues are concerned, they are not arbitrable in India. This was settled as early as 2011 in the Booz Allen, the landmark case of Booz Allen versus SBI Home Finance. And after the insolvency code coming in, again the case of Vidya Dolia by the Honorable Supreme Court of India further once again clarified that one centralized tribunal would look into issues with respect to corporate insolvency. And as far as intra-company disputes and issues of insolvency are concerned, they would be coming under the corporate insolvency regime and not arbitrable. So in India, as of now, between arbitration and corporate insolvency, the general tendency has been more so to bring in things towards the corporate insolvency regime. Even a couple of my earlier colleagues were talking about fraudulent trading, fraudulent transactions that must have happened way prior to the company going into insolvency. Even those come under so-called avoidance applications before the National Company Law Tribunal, and they cannot be arbitrated. So yeah, as of now, insolvency and winding up related issues and disputes are not arbitrable, and you need to go to the insolvency courts, which are popularly known as the National Company Law Tribunals in India.
Thank you. I think there was an interesting Court of Appeal decision in Singapore on this, but that's for another day, where there was an issue of arbitrability, but then they said you look at the law governing the arbitration agreement, and not law governing the contract or the seat, but law governing the arbitration agreement. And if it is silent, then you would look at the law of the seat. So this is an India-related case, but that's another topic in itself. I wouldn't travel into that. But moving on now, we always look at the common law world. Most of the arbitration actually emanated from the civil law countries, the continental Europe. So Ian, who's highly experienced in both civil and common law, dispute resolution. In fact, he has a master's from the National University of Singapore in the law faculty as well. So Ian, can you throw light from the law in Germany as well as other civil law countries on arbitrability vis-a-vis insolvency?
Yeah, sure. Thank you, Ganesh, for the invitation. Hello, everyone. I just want to quickly pick up on the term rendezvous. When you go on a rendezvous, you never know how it turns out. Here, if you have different legal cultures at play, there can be quite a few surprises. So I think it's very kind of you to also include the civil law perspective. Having said that, what is the situation in the civil law world? And the civil law world is not every civil law jurisdiction is the same. It's not like Africa as a country, but Africa is a continent. And all these questions, you have to look at each jurisdiction individually. Even so, within the European Union, you have some sort of unification already taking place with the insolvency regulation. In general, if let's take a starting point from Germany, it's very liberal. So every claim which relates to money is arbitrable. And that also applies to insolvency proceedings. And what you would look at the different legal relationships. So you would look at the creditor and the company as the debtor. And everything in their relationship, which is relating to monetary claims, can be arbitrated. And that doesn't change if the debtor becomes insolvent and gets under the administration of an insolvency administrator. The insolvency administrator just steps in and takes over the roles of the normal organs of that insolvent company vis-a-vis the creditor. So if there's an arbitration already pending, the arbitration can just go ahead. And the insolvency administrator steps in and he is going to handle the defense against the claim brought against the debtor. But the question, of course, is, since we now have an intermingling of two different legal regimes, the arbitration regime where you are actually there to enforce your claims to get the money into your own pocket, into the pocket of the creditors. In insolvency proceedings, the money doesn't go into individual pockets, but they go to an estate. So that means when you have your application pending before an arbitral tribunal, you need to change your request for relief. So it's no longer that you are requesting certain monies, but you have to ask that this kind of claim, as determined to be valid by an arbitral tribunal, will be part of what we call the insolvency table. So that will be a kind of a claim which is undisputed, and later on, if the insolvency administrator has seen how much money is there in the box and how can that be distributed, you are looking at all the claims which are accepted. And if there's an arbitration award against the insolvent company, that would be accepted as an undisputed claim. So that would be paid out in the share that's available. And it will normally be a very little share depending on the insolvency. So that's the one situation. And I think that's similar in a lot of other civil law jurisdictions where you take a liberal approach like Switzerland. Then there are other civil law jurisdictions like France and Italy where it's more restrictive. So it's not like you just continue with your arbitration and everything just needs to be adopted in terms of the request for relief, but it also means that everything is stopped. And you have to sort out things again. And then a lot of different laws come into play. So you have the law of the insolvency proceeding that's normally governed by the law at the forum where the insolvency has been opened. But then possibly you have competing insolvencies in different jurisdictions, so that can be quite a nightmare. Then you have the law applicable to the contract, then you have the law applicable to the arbitration agreement, and you have the law applicable to the arbitration at the seat. So there's a lot of competing views also across common law and civil law jurisdictions can apply in this mix.
Thank you, Ian, for that overview and the liberal approach that civil law countries take. In fact, when it comes to arbitrability, what Anant was discussing about the Booz Allen case of the Supreme Court, there are certain aspects of, for example, IP rights, intellectual property rights, like patent, which is a right in rem, which typically cannot be arbitrated unless it is a in personam right. For example, licensing agreement, yes, you can arbitrate, but if it's a right itself, it can't be. But I recall Switzerland was one of the first in the 1970s itself. They had a legislation where patent issues, even the issue right itself can be arbitrated. So I think now many countries have legislations encouraging arbitration, even in IP disputes. For example, Singapore has amended its Arbitration Act, so has Hong Kong and other countries. So arbitrability is a very interesting aspect, not only for insolvency, but for other subject matters as well. Now, moving on specifically to our topic today in terms of insolvency. Anant, starting with you on the moratorium, which we were speaking about, under the Indian Insolvency and Bankruptcy Code 2016, what is the effective moratorium on arbitration proceedings, number one? At the same time, when you cover that, can you also tell us whether proceedings for setting aside an award, which is filed under Section 34 of our Arbitration Conciliation Act 1996, should that be stayed when there is a moratorium in existence? Can you cover these two aspects, please?
Happy to, sure. So the concept of moratorium under the Insolvency Bankruptcy Code, of course, it was new as such. And it was a time-bound moratorium, unlike the prior regimes where with this SICA Act and the Industrial Reconstruction Act, so on and so forth, where the moratoriums were forever. Under this moratorium that a company is provided, it's technically a calm period where the company is given an opportunity to be restructured if somebody can find some potential in this company to revive it, take over, so on and so forth. So it prohibits any institution or continuation of suits or proceedings against the company. Now, that's the exact language that is being used. The word is corporate debtor, usually that we use in India, which includes arbitration proceedings. Now, this became an issue of interesting debate as to once a company is admitted into insolvency, what happens to the various arbitral proceedings that are ongoing. So this was clarified by the Honorable Supreme Court in the Alchemist ARC versus Hotel Godwan Private Limited case, which said that once a moratorium is declared, you neither can institute new arbitral proceedings, nor can you continue the existing ones. And therefore, now that the whole proceeding has become a proceeding in rem, so there was a stay on arbitral proceedings per se. Then interesting perspective of this was the Supreme Court's view in the case of New Delhi Municipal Corporation versus Minosha Limited, where the Supreme Court clarified that any proceeding against the company, as far as arbitral proceedings are concerned, they would be impacted and stayed because of the moratorium, but not proceedings which are initiated by the company. So that can be continued by the insolvency professional, because ultimately that is for the benefit of the company. And if some funds come in, they come into the kitty of the company per se, which will be distributed to all the creditors in a certain waterfall mechanism. So that was a distinguishing feature. With respect to Section 34, which is setting aside of an arbitral award, the interesting part here was that the power grid judgment of the Delhi High Court gave a very interesting perspective, saying that you can continue a Section 34 proceeding as long as it is not causing detriment or reducing the assets of the company undergoing insolvency process. But if it is the other way around, you should not continue with the proceedings under 34. But by and large, on the ground level, we've seen that proceedings under Section 34 are stayed by the High Courts. And in fact, in the same judgment, the court also covered that even if under 34 there is an order that comes out which could be detrimental to the company undergoing insolvency, execution of that, which would lead to a detriment to the company under insolvency, cannot be done. So therefore, even if you succeed in a 34, you cannot enforce it in a 36. So, but this issue was again raised up in another case of Mohan Raj, and it's still a controversy that's left open. Because if you allow 34 with such riders, setting aside proceedings, then that would lead to further, I would say, debates. And therefore, that issue still remains to be a controversy which should ideally be settled, that 34 should it be allowed, blanket or not, and in under what circumstances should it be allowed. So that is with respect to proceedings under 34 and 36 and the impact on moratorium. The overall intent is any form of recovery from the company has to be put on hold.
Thank you. Thank you so much for that excellent overview of this complicated, rather topic. And see, since you're here, I would like to, Anant, take the benefit because you've on the IBC itself, Insolvency Bankruptcy Court. We so much of talk about resolution plans to revive companies and all that. But just stepping aside from this topic, if you can spend about a minute or two to tell us what is actually happening on the ground in India in terms of these resolution plans. I mean, is it really working? What is the ground experience? I think this is something which will be a good takeaway for our participants today.
More than happy to. So, very difficult to cover this in a minute or two. I'll make my best efforts because this is something which in itself is a question which possibly would require a good 45 minutes for discussion as to how effective are the implementation issues with respect to insolvency laws in India. But having said that, that is usually a narrative that the corporate insolvency regime in India is slow, it's not doing justice, it's not being fast, and the resolutions are not happening. But on the ground, I would always go by the data, the statistics. The numbers speak a lot. First things first, about 7,000 to 8,000 companies which were admitted into insolvency, a good 2,500 odd companies have already come out of it by way of a settlement one way or the other. So the Indian, if you see this insolvency code, IBC has had a very positive impact on the psyche of the Indian promoter who would at one point in time think that the lenders would go behind them in the banks and arbitration, and it will go on forever. So they're settling, they're coming out, and they're getting their company back. That's one part. Even the remaining companies, companies which are undergoing the insolvency process, there has been a significant amount of successful resolutions. About 900 plus resolution plans have been approved, implemented. Many housing projects which affect the common people in the country, they have been brought back to life. They have been given life to. And claims worth, I can say that in Indian rupees, about 3.5 lakh Indian rupees, but that would be a few $million and so on and so forth. That has actually fructified. Monies are coming into the system. Companies which are in distress are actually being opened up and acquired by better players or players who are in a position or who have the bandwidth to run these companies, revive them successfully, and even an extended form of the corporate insolvency process, which is the liquidation. Even under liquidation, the Supreme Court has said that, and it has been happening on the ground, where you can still revive a company as a going concern. So ultimately, the insolvency code, I would say in India, has been a success. there are certain infrastructure and ecosystem issues which are being developed and evolved. But by and large, it has been something which India should be proud of. And touching on that, connected just one about 30 seconds on this issue. As we lawyers are used to, Lord, just give me another 30 seconds more on this limited issue. It also gives clarity in terms of once a company undergoes the insolvency process and it goes through something called the clean slate theory, as per the Ghanshyam Das Mishra judgment of the Honorable Supreme Court, which means that even if you have arbitrable claims against a company which has gone through a process, right or wrong, that could be a different issue of debate. But once the new acquirer of the company gets the company, they get the company without any further claims as a clean slate. And that's something which gives them the comfort that you don't take a company with uncertainties and, as they say, Hydra heads popping up, as it was mentioned in one of the Supreme Court judgments. Thank you.
Thank you, Anant, for that value add that you just provided. Now, moving on to moratorium in other jurisdictions very quickly. I mean, if first Ajinder, what's the position in Singapore?
Thanks, Ganesh. So I will add to the confusion on this topic. There are two different types of moratoriums, and I think it's been alluded to by Anant. You have a moratorium in liquidation, and then separately you have a moratorium for restructuring process. So in Singapore, if you want to restructure a company through, for example, the English scheme of arrangement is the similar process, you file for that moratorium. And the idea is to give the company breathing space. So this issue as to what happens to arbitrations in the face of this type of moratoriums has recently, only this year, come up before a court of appeal in a case of Sapura fabrication. So what happened there is simply the court of appeal said, for a moratorium for liquidation, we will not accept the position that you have to do it on an exceptional basis, meaning lift the moratorium and let the arbitration go on. What we will do is consider it on a case-by-case basis. Reason being, there is a liquidation, company is already bankrupt, insolvent, not enough money, so why complicate matters through an arbitration proceeding, which is expensive, preserve the assets and let the liquidator deal with it. But when it comes for a moratorium for restructuring, this litigant, what they kind of made the case was in Singapore, further confusion has been caused by the issue of arbitration and winding up. So in the face of a winding up application, sometimes some proponents will say, look, I have a dispute on the winding up. I don't agree. I owe money, and at the same time, I have an arbitration clause. So in this sort of cases, given that everyone is going pro-arbitration, the test that the Singapore court came up with was, we will just examine things on a prima facie level, meaning we won't inquire very deeply into whether or not there is a dispute really whether or not you really owe money, but because there's an arbitration clause, just on a prima facie check, we'll allow it go for an arbitration. So the litigant said here, in terms of a moratorium for restructuring, the test should be similar. Let me go for my arbitration and come back with the result, because we take a light touch approach to arbitration. But the Court of Appeal here then had to maneuver around its earlier decision and said, moratorium for restructurings are meant to give companies breathing space. So in that sense, you cannot just, as a blanket practice, allow everyone to go for arbitration, because it's going to exhaust the resources. Give the company time, come up with its scheme of arrangement, see whether you're happy. So in that sense, we are not going to allow arbitrations to continue just like that. We will still examine it carefully. And so you need a very high standard, high factors to allow you to go for an arbitration in the face of a moratorium for restructurings. So that is the position.
Thank you. I think very beautifully you kind of compared between a normal insolvency and the restructuring and the two different moratoriums. I think, Hannah, if you could just throw light from the perspective of English law position on this, the moratorium.
Thanks, Ganesh. It's quite similar to the Indian position in that where there's an insolvency process such as liquidation or administration and it's ongoing at the time the arbitration's commenced, an automatic moratorium will prevent the arbitration from proceeding unless leave has been given by the court. So it's slightly different depending on what type of insolvency process. So in liquidation, where it's not voluntary and there's a winding up order and appointment of provisional liquidators, there will be this automatic stay subject to any terms that the court imposes and with leave of the court. If it's a voluntary winding up, the court has a discretion to order a stay, but again, the situation is slightly nuanced. Similarly, a stay on the same terms is available in relation to recognised foreign insolvency proceedings. And with administration, no legal process can be continued against a company in administration without permission from the court, or interestingly, different from liquidation, you then need the consent of the administrator. So there's slight nuances depending on what type of insolvency you have, and also sort of at what stage you're being. But the English language is very much that there's a stay rather than a moratorium. But this can be lifted depending on the discretion of the court. So the court will look at all the facts to decide whether it's right and fair and in the circumstances to lift the stay, and with a particular focus on the interest of creditors. And Costco Bulk Carrier Co. Limited from 2011 is the main decision on this. But sort of from my experience in the case law, the factors the court really looks at is, are proprietary rights at stake? Is it limitation period going to run out if the stay isn't lifted? And they're the types of factors that the court will look at. But just a quick note in terms of the situation on the ground, the number of registered companies, insolvencies in England and Wales is really quite a record high. 2023 saw a 30-year annual high in terms of numbers of insolvencies, and 2025 is comparable. There was a bit of a dip in 2024, so this really is a live issue, and us insolvency practitioners in the UK are very busy at the moment. So it's topical in our jurisdiction at the moment in terms of what process gets priority.
Excellent. Thank you so much. Jan, can you please tell us the position of moratorium vis-a-vis arbitration in Germany?
Yeah, sure, Ganesh. Just to make it very simple, there's no moratorium and there's no stay. So what happens in practice if a debtor becomes insolvent, and that would equally apply if the insolvent party is the claimant. So what happens? The managers of the companies, they have no longer power of attorney, so the insolvency administrator would step into their shoes. And that's the process where the arbitral tribunal would get informed, saying, well, there's an insolvency, there will be a change of actors. But for the tribunal, there's normally no need to adapt the timetable or anything. They just say, okay, get up to speed and continue with it. But normally in practice, arbitrators would then likely call in a case management conference, say, okay, let us know what the situation is. How familiar are you with the case? How much time do you need to get up to speed with it? So basically, there is a kind of a informal stay just so that everybody can rearrange their positions and their preparations, but then it just continues as normal. And the insolvency administrator just cannot sit back and say, well, I'm ignoring the arbitration proceeding, because, as you know, if a party doesn't appear, the arbitration proceeding can still continue to run. So there's no protection, statutory protection for an insolvency administrator in this situation. And similar, if an insolvency administrator wants to enforce a certain claim that he has against a debtor, he or she just brings an arbitration proceeding, and that's just a normal process. And the other side, the respondent who is not insolvent, just has to react and participate in it. That's again a very liberal position taken in Germany and Switzerland. In Italy, if you look at that, there is a kind of a mandatory stay. All the cases will go to the insolvency court, and they will determine the claims. In France, it's also a kind of a stay. It will be a question for the court to determine what parts of the dispute can go to arbitration. Maybe it's quantum. So there's a kind of a gatekeeper role, but that you don't find at all in Germany. The only change, as I said, is you cannot get a title for money. you can only get a title that your claim will be tabled or included as an undisputed claim in the table of claims that the insolvency administrator will take into account when there's a payout day.
Excellent. See, ladies and gentlemen, from what we have heard from all our eminent panelists, even on this moratorium, there seems to be different approaches, different pointers in each jurisdiction. So for all our friends who are from the industry and legal counsel, the only information I want to tell you is please consult your lawyer. It's extremely important to speak to your lawyer in whichever jurisdiction you're involved. If your company is probably going towards that stage, I hope it doesn't. But still, I think it's extremely important to get legal advice because, especially when you're doing cross-border transactions, it's extremely important to get advice from different set of lawyers on what are the possible issues that may arise. With that, I think we have covered arbitrability and moratorium very effectively, in my view. And let's move on to this very interesting, development that's happened in Singapore with the Singapore International Arbitration Centre having launched the SIAC Restructuring and Insolvency Arbitration Protocol just a few weeks back on the 26th of August. It has also come up with some guidance notes. You can all look it up on SIAC's website. It's an interesting development, I think. Ajinta, could you please enlighten us on this?
Thanks, Ganesh. And kudos for putting together a seminar which covers the whole world in 1 hour in terms of insolvency. So this is the latest development in Singapore. How this protocol works is it's meant to give a framework for how insolvency-related arbitrations can be heard. It works in tandem with the existing SIAC rules with some adjustments. And for one big adjustment is in terms of time. Whoever is appointed as arbitrator or arbitrators for this sort of cases have to get their award out in 6 months. And there's a reason for this as well. I'll come to that. So the other thing that is important about this protocol is this. I mentioned Larsen's case, and Hannah and Jan and Anant have been amplifying the issue as to what is arbitrable, what is not. And usually cases that are on contract disputes should be arbitrable. But you go back to Larsen, the problem was, yes, there's an arbitration clause, but there is no, in terms of time, that arbitration clause or the agreement was entered into way before the insolvency arose. So the one issue that the court grappled with was, could it be said that the arbitration clause covers this sort of insolvency events? Could it be that case that the parties thought so deeply at that point? And the general traditional approach was, in Singapore, when it comes to insolvency, they send it to court, especially for wrongful trading claims and whatnots. So this protocol tries to address that by doing this. There are model law clauses available for parties to adopt in terms of if you want to use this protocol. So what it calls for is you use this model clause, which says you adopt the SIC rules together with this protocol. And if you do that, you are expressly deemed to have waived objections to arbitrability. So the thinkers behind this think that with that, then it solves the problem of somebody raising an issue down the road to say you went for arbitration on an issue that's not arbitrable in terms of a set aside. But then this waiver will come up to say, no, but you agreed to waive it. The other thing is the width of this protocol. It applies not just to, say, two companies. It applies to insolvency office holders as a whole. So that means who? That means liquidators, administrators, scheme or restructuring professionals, and even directors who are caught up in an insolvency situation. So this protocol works in two ways. You can put it in your agreement right now, or at the start of a dispute, you can use it, and the insolvency office holders will obviously do that. And with that, then you got a wide-ranging sort of audience or participants who can use this protocol to get their cases through insolvency. So coming back to Larsen, in today's regime, with this protocol, what happened there would be arbitrable. The other question then I need to answer is basically this. Why then has Singapore done this? What's the point of this? And this protocol was 2 years in the making. There were many breakout sessions, town halls. And when I was asked about this initially, my view was, is this going to work? Because insolvency, if Indian parties come and use this protocol and arbitrate in Singapore, what happens then if they go back to Indonesia and then one party decides to raise the issue of arbitrability, notwithstanding the waiver? So to address that, this protocol does something unique as well. The default rule is, if you agree to this and you adopt this, the seat by default is Singapore. So the idea being, even if there's a challenge back home or in other countries, because Singapore law recognizes it, then it shouldn't be set aside. And you touched on this slightly, the law of the arbitration should govern rather than the governing law. So that's in the case that you mentioned, Ganesh, at the start. So that's the idea behind this protocol. The other reason has to do with what Yan spoke about and you briefly spoke about is cross-border insolvencies. So the world is getting complicated. You're no longer dealing with domestic arbitration, domestic insolvencies. You have sometimes with complex groups, multiple insolvencies in numerous countries. And so in Singapore, you have this, what is known as the Singapore International Commercial Court. They are trying to become a restructuring hub for Asia. So, for example, you have a cross-border issues all over the world. The idea is come to Singapore, you can start your restructuring here and get it recognized in other countries. And so as part of that movement, this protocol has been designed so that parties in the middle of restructuring, for example, there are always satellite disputes between creditors on whether who's owed what, who ranks above. And the idea is for them, they can then opt for arbitration, quietly go off and get their case heard through this mechanism, and then come back to the court for the restructuring proper. So that's why there is only a 6-month time frame. I hope that helps in terms of understanding why Singapore is
Yes, very much, Ajinder. I think you have covered such a big topic in a really nutshell fashion, which is very useful. I mean, this is also a great thing about Singapore and SIAC. Though you can say catch-all situation, catch-all kind of a thing. I can only be proud as an SIAC alumni that this is something which unique, which SIAC has started, and I'm sure other arbitral institutions may follow suit. It's always good to propound something like this in new areas, and that's what is important, because as a dispute resolution mechanism, arbitration is always there, but you need to address the problems of the users. You need to be relevant. Otherwise, it's just going to be the same process, and you don't address the issues which are relevant to the day. I think then all this is okay. Thank you for that, and I'm sure this we'll see how this protocol works. And as you rightly pointed out, it all depends upon when you go to enforce this award in a foreign country, if it's cross-border, then these issues could create an issue. But they will wait to watch that space. The next, point I wanted to discuss is at the end of the day, all of us, go through the arbitral process for this beautiful document called the Arbitral Award. So it's for this arbitral award that all this is being, done. Can an arbitral award be a basis for initiating insolvency proceedings? Hannah, can you start off on this subtopic?
Thanks, Ganesh. And I think it's really interesting to hear about the protocol. I mean, my understanding is it's now been effective since the 26th of August, but it will be really interesting in practice to see commercial parties, whether they take it up and if they're able to agree on the position once you've got a dispute rolling, because we all know that's when it can get contentious. And if there is going to be an arbitrability point taken, it may be difficult to agree that the protocol's sort of then in place. So I'm really interested to see what the uptake by commercial parties is, and if other institutions, as you say, Ganesh, also then adopt something similar. My interpretation is that the protocol was a response to Larsen, which is perhaps more strict than English law in terms of arbitrability. So it will be interesting to see sort of what the English response is in relation to the protocol. But I think it's such an interesting and important development in the world that we are in at the moment. In terms of whether an arbitral award can be a basis for initiating insolvency proceedings, in England, the simple and quick answer is yes, in theory, subject to caveats and interesting lawyers' arguments about why it can't. I'd be amiss to not mention a very large Privy Council decision last year, which has changed the area, and it was very much linking to something that was earlier said about the relationship between winding up proceedings and arbitration awards. So we had this decision last year concerning whether a company should be wound up when the debt on which the winding up application is based is subject to an arbitration agreement and is then disputed or subject to a cross-claim. And this is the Cyan Participation Court v Alameda International case. And this has really changed the law in our area. And the position now is, if there is an arbitration agreement, the winding up proceedings is only going to be dismissed or stayed if there is a genuine dispute over the debt on substantial grounds. And it determined that the previous leading English authority of Salford Estates was wrongly decided, which said that the court should, save in wholly exceptional circumstances, stay the proceedings. So there's been this real shift now in England, and the test is that a winding up petition for a disputed debt, which is subject to an arbitration agreement, will now be stayed only where there is a genuine dispute over the debt on substantial grounds. And in my opinion, this strikes a more fair balance. It means that the choice of dispute resolution forum will not impact the parties' ability to engage with an insolvency process. And it also prevents creditors from having to participate in arbitration proceedings with debts that aren't genuinely disputed. So again, it's finding the balance between these two competing procedures. But again, this Privy Council decision shows that this tension is ongoing in all jurisdictions.
Thank you. In fact, India did away with Privy Council appeals more than 75 years back, but still, when you say Privy Council, we all respect it a lot, because traditionally Indian cases used to go to the final appeal to Privy Council. So also as Singapore, but both Singapore and India have now, we have our highest courts in Supreme Court in India and the Court of Appeal in Singapore. But that said, thank you so much for throwing light on that from the English law perspective. And Anant, very quickly on the Indian law, on this aspect, if the arbitral award can be a basis for insolvency proceedings.
Just before I respond to the specific question at hand, when we were talking about the SIAC Restructuring and Insolvency Arbitration Protocol, there's a lot of discussion that's happening in India with respect to insolvency and mediation as well. And at what stages can mediation be brought in as a mechanism of resolving issues between interstate? It eventually boils down to be a lot of negotiations between financial institutions vis-a-vis the borrower, so on and so forth. So that discussion is already it has started in India, and we hope that India brings out something similar, at least some is inspired by the arbitration protocol from Singapore. Now, coming to the specific question, whether an arbitral award, does it become a good ground to initiate corporate insolvency? The answer as such is yes, something similar to what Hannah had said. But similar to the UK law, now there are 3 or 4 similar caveats as well. As long as the arbitral award is final, it's binding, there are no challenges under Section 34 or so on and so forth pending, and there's no dispute in and around the arbitral award. In which scenario, once the time given under the Arbitration Act for challenging an award and all of that is done and the award has attained finality, the award can be used as a basis for initiating arbitration proceedings. By the way, in India, insolvency proceedings, I'm sorry. So insolvency is initiated by either as an operational creditor or as a financial creditor. The operational creditor, the angle that becomes important is again a pre-existing dispute, something which briefly Hannah also touched upon, that this pre-existing dispute gets connected if your arbitral award, basis which you are initiating insolvency, is under an appeal or under a challenge. So therefore, which means there is a dispute, and then you cannot use that arbitral award to initiate insolvency in India. But if it's the other way around, if there is no dispute, and especially if it's a financial institution that has attained an award, you can. But the other interesting angle, and this was decided by the Vijay Nirman case of Supreme Court in 2018, The other interesting case in this is the 2022 case of Cholamandalam Investment versus Navran Road Lines, which was by the Madras High Court and upheld by the Supreme Court of India, where again similar issues were decided. It was confirmed that an arbitral award, if it is final and binding, can be utilized to initiate an insolvency proceeding. But just because an arbitral award has an interest component on it, you cannot change the nature of the underlying transaction between the parties. So if the underlying transaction was, let's say, for a sale of goods or services or an operational debt, you cannot then file as a financial creditor when you initiate corporate insolvency proceedings. So yeah, that's the only interesting part that comes out in this judgment. And yeah,
thank you, Anant. Thank you. I know when you get into operational creditor fund, it's a separate topic in itself because IBC is so vast. There's so much case laws on this in India. We have a hard stop in a few minutes. We'll finally, invite Ian for the position on any of these things discussed from a civil law perspective.
Yeah, so thank you, Ganesh. I think the Singapore product that just has been put on the market, that's really an interesting idea to get as a kind of an animal of party autonomy to remedy a kind of a situation that you would like to play out differently. I think probably from a civil law perspective, from a German law perspective, given what I've told you about our situation, we would not need that protocol. But of course, if a German company operates in Asia with Asian counterparties, it may well be well advised to look at it very carefully and try to centralize things in Singapore to get it administered. So what happens in Germany if you have an arbitration award against you and that's final and binding? Well, the management of the company, they need to move fast because they are under legal obligations to initiate themselves insolvency proceedings if they lack the cash or they don't lack the kind of the net balance sheet if you compare it. And if they don't do it in time, there will be criminal liability imposed on them. So a lot of the management, they are very careful monitoring the situations. Of course, if they're being faced with a kind of a non-meritorious claim, they may not even make a provision in their accounts for it. But if there's something to it, I think they also need to make provisions, and that's the normal situation. So whether there's an insolvency proceeding not yet initiated when the arbitration award comes out, or if there is a claim raised that hasn't been decided in arbitration, it's always the kind of management that needs to take a clear view on it and make it a judgment on it. And that may lead to insolvency proceedings. Of course, it also a creditor can suggest insolvency proceedings. So that would then come from the outside. That's also sometimes used as a tool to put maximum pressure. So, different situations that can apply. But an arbitration award, which is final and binding, is certainly possible to trigger insolvency proceedings under German or, for that matter, civil law proceedings. Thank you very much.
Thank you. Thank you so much, Jan. I think that kind of brings us to the close of this, wonderful discussion we've had in the last almost an hour. And as Ajinder rightly said, it's not easy to compress this wide topic in about an hour. It probably is a discussion for a day. I think this is probably a precursor to a seminar where we can have discussion between comparative analysis of this topic. And everyone is now talking about the Singapore Protocol. If it is going to be successful, I'm sure perhaps in due course other institutions will follow suit, and because SIAC will not be worried because imitation is the best form of flattery. So in fact, the rules, arbitral rules, institutions borrow from each other from best practices. Like the emergency arbitrator was actually started by AAA, ICDR in the US. And now almost all the top institutions in the world have emergency arbitrator provisions in their rules. So with that, I really thank all of you, Hannah, Jan, Ajinder, Anant, for having engaged in this fantastic discussion. Thanks to MCIA for inviting the India International Arbitration Centre to be part of the India ADR Week and to hold this webinar. Thanks especially to Madhukeshwar, Neeti, Dohita and Anushka and all the others in the MCIA Secretariat for inviting us. And on behalf of IIAC, the chairperson and the Secretariat, thank you all once again and wish you a great India ADR Week. Thank you.
Yes.
We will be starting the next session at sharp 5. So if anyone wants to grab a quick cup of coffee, please do so now. Thank you.